Yes. Yeah, so we looked at all those. So we can, in this case, look at the very first question, which is here. It says it is from December 2024. It is question number 1A. It says, in relation to company liquidation, explain the term compulsory liquidation. Then Roman number 2, list 5 parties who can petition for the compulsory liquidation of the company. So this compulsory liquidation, we gave it another name. There's another name we gave to compulsory liquidation of a company. Mama Khalifa, what is the other name for compulsory liquidation? Takeover, not takeover. We didn't actually call it takeover. Court order liquidation. Or you can make the statement a bit better. We also call it liquidation by the court. So we call it liquidation by the court. So we also call it liquidation by the court. So it is where the company is actually compelled to be liquidated. And in this case, the liquidation process commences by issuance of a liquidation order by the court. It is where the company is forced to be liquidated or is actually compelled to be liquidated as a result of the court having to issue what we call a liquidation order. So we call it compulsory liquidation. But apart from compulsory, or in this case, liquidation by the court, or what we call liquidation by the court, we have other 2 kinds of liquidation. So in this case, I have compulsory liquidation, which you're having to also call liquidation by the court. So it is liquidation instigated by the court, or in this case, liquidation as a result of an order given by the court due to a number of reasons, which in this case we looked at. So we have in this case voluntary liquidation, but you said voluntary liquidation, you can split it into 2. So that gives us 3 forms of liquidation. So we can split voluntary into 2. We can split voluntary liquidation into 2. So we have voluntary liquidation by members and voluntary liquidation by creditors. So voluntary liquidation by members and voluntary liquidation by creditors. So there are in this case 3. So we can talk about compulsory liquidation, or what we call liquidation by the court, or we can talk about voluntary liquidation by members and voluntary liquidation by creditors. So voluntary, just from the term voluntary, the company is having to be voluntarily liquidated. Then we said in this case, for compulsory liquidation to be undertaken, or the court in this case to issue an order for compulsory liquidation, there has to be a number of parties who in this case are supposed to do what? Who are supposed in this case to do what? To petition. Who are supposed in this case to do what? To petition for the compulsory liquidation. Who are these parties who can petition the court for compulsory liquidation? Who are the parties who can petition? By petitioning basically simply means you having in this case to present reasons. So we can have the company itself, we can have the creditors. So the creditors, I can see you're saying creditors, Irene creditors, Felicitas creditors. Everyone here seems to know creditors. Everyone just seems to know what creditors. So you have creditors, the company itself, the members, the attorney general. The attorney general, shareholders and members is the same. It can't be the liquidator. So blessed, is it blessed? You can't say liquidator because even liquidation hasn't commenced. Liquidator comes after the liquidation has commenced. We have administrator or receiver. So in this case, you have the 5 parties, administrator or receiver. So those are amongst the parties who could actually end up having to petition the court, in this case, to issue a liquidation order for the company to be compulsorily liquidated. So there are those ones. So when you talk about compulsory, this is a court-ordered winding up of a company, usually initiated when the company is unable to pay its debts or any other legal grounds. So we have in this case what we call reasons for compulsory liquidation. So in this case, the court will end up having to appoint an official liquidator or a provisional liquidator to take control, realize the assets, and distribute the proceeds to creditors, and if possible, there are any remains to the shareholders. So there is this one, the reasons as to why in this case, a company could be compulsorily liquidated. We have in this case a number of reasons. Or what, in this case, these reasons that the court could be able to look at and in this case say it is reasonable. Now, in this case, the company could actually be liquidated and therefore they issue a liquidation order. What are the reasons the petitioners must be able to bring before the court? If he is unable to pay what? Its liabilities, unable to pay its liabilities. If it is unable to pay its liabilities, what are the other reasons? Due to public interest. If the number of members have actually fallen below 2 and the company has continuously operated for a period of more than 6 months, if there's a reduction in the number of Ngutara and 349415, Ngutara and 349415, you need in this case to further refine your point and say, if in this case membership has actually fallen below the statutory minimum requirement of 2 and the company has continuously operated for a period of more than 6 months, if in this case the company has passed a special resolution deciding it is going to be liquidated by the court under just and equitable grounds. So what are these just and equitable grounds? What are these just and equitable grounds upon which in this case now the company can be liquidated? We have a number of them. What are the just and equitable grounds upon which a company can be compulsorily liquidated? So this simply means in this case for justice and equity to prevail, we are far much better off if the company is liquidated. So we have in this case grounds and what we call what? Just and equitable grounds. And you have to be very keen. In the exam, they can test specifically just and equitable reasons. They can test what are the just and equitable reasons upon which the company can be compulsorily liquidated. So if the company is continuously making losses, if the company is involved in fraudulent activities, if the company is continuously making losses, if there's exclusion in management, so that's another point under just and equitable. If there's exclusion in management, that one of the managers, or in this case, the person in charge of management, has been excluded from management, that is correct. If the company is involved in fraudulent activities or illegal business, if there's a failure of what we call the objects or the substratum. So the main reason as to why in this case the company was formed has not actually been met. That can be amongst the just and equitable reasons. If it's carrying out illegal activities. If in this case there's what? A deadlock in the management, where if you have like 2 directors, they are not able to see eye to eye. If there's a deadlock in what? In the management. And therefore in this case, directors are not able to see what? Eye to eye. Where there is what? A continuous breach of trust amongst, for example, what? The management or the key shareholders. Yeah, so those are in this case the reasons under what we call what? Just and equitable grounds. So take note. They can ask specifically the just and equitable reasons as to why the company could end up having to be liquidated. So you have to be keen about that. The 5 parties who can petition, we can talk about the company itself. So through what? A special resolution, the creditors, particularly when the company is unable to pay its debts, contributories, shareholders or members, persons liable to contribute to the company's assets in liquidation, the official receiver, or in this case, administrator, usually acting for the benefit of, in this case, what? Public interest. Or we can have, in this case, also the Attorney General, due to public demand. Due to public what? Demand. Due to public demand. Then we have this one from August 2024. Question number 6B is in this case from what? From administration. Summarize 7 roles of administrator in a company that is under administration. What do you think will be the role that in this case an administrator will be able to undertake when in this case is having to take charge of administration in a company? Appoint a board again. To maintain the company as a going concern, that is a very valid point. A very strong point there from Jen Joyce. To maintain the company as a going concern. staffing, maybe don't say staffing. You can be able to say in this case, you can actually be able to appoint agents or experts to be able to support him in terms of having to manage the company. Appointer liquidator, really? Not really. Appointer liquidator, not really. So power to distribute the company assets to creditors. Very correct. Very correct from Paris. So we said in this case, majorly the administrator basically comes in to manage the company to ensure it is afloat, or in this case, it can exist for the foreseeable future. Then in this case, also secure or safeguard the assets for what? For specific creditors. So to convene the meeting of members and of course what creditors, to take control or management of the affairs of the company. So the duties basically would like to be able to surround under having to, in this case, take over the assets and dispose them off and recover as much enough money to be able to pay what specific creditors, or in this case, to take charge or management of the affairs of the company to continue to exist as what? As a going concern. So the duties will be able to surround those particular two major objectives of, in this case, what? Administration. So we can talk about managing the company affairs. So you'll be able to come in and take control of the company affairs. So you'll come in and take control of the company affairs to administer the company. Because now in this case, we said when you talk about administration, it's like having to take the company to the hospital. It is very sick in the sense that it's not even able to do what service its liabilities. So it means probably it could be due to mismanagement, and therefore to save the situation or save the life of the company, it can be put under what? Administration. And therefore, as he's having to come in, he'll take over the overall management of, in this case, what? The affairs of the company, in charge of the company, in charge of, in this case, what? The company. So to manage the company affairs, to rescue the company as a going concern, not to lead the company in having to go under, but he can try to save the situation. Other than the company having to be liquidated, he's trying to save the situation. It continues to exist for the overall benefit of all the stakeholders, amongst them creditors because they can be repaid back, amongst them employees because they can continuously now work in the company. Protect or safeguard the company assets for the benefit of, in this case, what? The creditors. Prepare an administration plan, outline steps for recovery or reorganization or restructuring of the company. Negotiate with what? Creditors. For example, in this case, enter into schemes of arrangement. In this case, to be able to do what? Restructure, or maybe in this case, arrangements regarding their repayment. Maximize returns to what? To creditors. Secure the assets specifically charged by what? The creditors, and in this case, dispose them off. Get adequate amounts of money to be able to repay back the creditors. Then in this case, at the end of it all, he can be able to prepare what? A report to, in this case, share with the key stakeholders, who in this case can be creditors, shareholders, or maybe in this case, if exactly what? The court that is actually also involved in the administration. So those are, in this case, what? Part of the duties of, in this case, the person you're having to call an administrator. So we can go to the next one, which is April 2024, question number 3A and D. So the first one says, outline the priority of distribution of assets of a company after dissolution. Then explain the following terms. So receivership, administration, and of course liquidation. So this is what we just looked at in our previous discussion. So then in this case, there are only two. So we have in this case part A and part D. So the priority of distribution of assets on the dissolution of the company. Dissolution of the company is when the life of the company has completely come to an end. We've actually been able to secure all the assets, and in this case, you're supposed to do what? Distribute. Then we prepare a report, and in this case, deliver to the register of companies to dissolve, or in this case, after dissolution, in this case, you're having to mean the company will no longer exist as what? As a person. So the priority as to how they can be able to distribute the assets. So they'll first of all, in this case, settle. There's an order which in this case they settle when the life of the company is coming to an end. So first of all, in this case, there'll be the payment of the liquidation cost or expenses. They'll start with these ones. All the liquidation cost or expenses have to, in this case, be settled out of the assets. So once the assets have been disposed, they have sold, they have gotten money, then first of all, they have to settle what? All the liquidation expenses, pay the liquidator, pay all the experts who are involved in liquidation, So any liquidation expense will first of all have to do what to be settled. Then number two, after that, they'll settle secured and what? Preferential debts. So including employee wages, these are like employee wages, the government taxes, and what? The secured creditors. So they like in this case payment of what? Key expenses or priority expenses, like maybe in this case taxes to the government. Then after that, those creditors who are secured. So you have in this case secured creditors. They're now in this case secured. They are the ones in this case who've actually been able to charge the assets of the company. They are secured. So they'll first of all settle what? Secured creditors. Then after that, they'll go to unsecured. Unsecured are basically in this case those who don't have any form of security in the company. They didn't secure the amount the company is having to owe them with any asset in the company. They are unsecured. So they'll in this case settle them. Then after that, if it happens there are any form of remains, then in this case, they can be shared as what? As a surplus to the members. So this one can be number 4. So in this case, it will be followed by any surplus to what? To shareholders. And in this case, under shareholders also, there's a priority. They'll start with the preference shareholders. Then they go in this case to what? To ordinary shareholders. So like that. So they'll go to ordinary shareholders now. So that's in this case like what? The priority. Whenever in this case the life of the company is coming to an end, that's how they settle their liabilities and expenses in that order of ranking or that order of priority. So receivership. So receivership in this case, you say it is when a person we call a receiver ends up having to be appointed. And in this case, what happens? He'll be able to safeguard or protect the interest of a specific creditor. So that's in this case what? Receivership. But now we have what? Administration. Administration is a situation whereby a person we call an administrator is appointed to manage the affairs of the company for the benefit of all the creditors and other stakeholders of what? Of the company. So take note of in this case the difference between the two. We're having to say under receivership, a person we call a receiver is appointed to safeguard or protect the interest of specific creditors within the company by having to do what? Safeguard or secure the assets which they had charged in the company. Under administration, it is for the interest or the benefit of all the creditors. Further to this, we're having to say, under administration, the administrator takes over the management of the affairs of the company to, in this case, sustain it as a going concern to exist for the foreseeable future for the benefit of all the stakeholders. So you can see under receivership, safeguarding, protecting the interest of a specific creditor by securing, for example, what? Charged assets. Administration, taking over management of the affairs of the company to sustain the company as a going concern for the foreseeable future, for the benefit of all the creditors and any other relevant what? Stakeholders. So that's in this case what you're having to call what? Administration. So as in this case, you're having to say, when you talk about the receivership, is the process where a person we call a receiver or a receiver manager is appointed by a secured creditor, such as a debenture holder, to take control and realize specific company what? Assets. You can see in this case specifically is having to play the role of having to, in this case, what? Secure specific assets for what? For a specific creditor. So the main aim is to recover the debt due to that creditor. But in this case, what are we having to say happens under administration? Is a situation where a person we call an administrator is appointed to take over the overall management. Over the overall management of, in this case, what? The affairs of the company. And in this case, sustain it as a going concern, or in this case, just have an overall better outcome for all the creditors of the company. So these are like, in this case, the objectives of, in this case, what? Administration. So these administrators, we say, they can actually be appointed by the courts, it can be appointed by the company or its directors, or in this case, a holder of what we call what? A qualifying floating charge. So these are the parties who can be able to end up having to appoint an administrator. So that's what in this case happens under the two. Then liquidation, ideally in this case, is the process of ending the life of a company or winding up, in this case, what? The life of a company. It can be in two forms. We can be able to have what we call compulsory or voluntary. Under voluntary, we have two. We have voluntary by members and voluntary by creditors. Voluntary by members and voluntary by creditors. So it is the process of winding up a company's financial affairs by realizing its assets and distributing the proceeds to creditors. And in this case, if it happens, there are any residues, they can be shared amongst shareholders. Then after that, the company is deregistered from the register at the registrar's office. So after the liquidation process, then the life of the company would have come to an end. So that's in this case what we mean by liquidation. So highlight 4 powers of an administrator. These are almost basically similar to in this case what we've been able to talk about as what as the duties. So manage the company business and property, sell or otherwise dispose the company property, borrow money. So in this case, you can be able to raise funds needed to maintain the operations or support what restructuring of the company, commence, continue, or defend what any legal proceedings for or against what the company. So those are part of, in this case, what the powers of the administrator was actually been appointed. Describe the process of appointing a receiver during what the winding up of a company. So in this case, there has to be, like in this case, a ground upon which in this case you want to appoint a receiver. For example, it could be maybe there has been a default by the company to pay a specific creditor. In this case, exactly what a secured creditor. So identify the grounds for appointment. So usually arises when a secured creditor wishes to enforce a security interest. So there's in this case a creditor whom in this case the company has not actually been paying his or her due amount. And in this case, part of the agreement under the lending of money to the company, he has been given the leeway to be able to appoint a receiver to take over secured assets or recover secured assets, dispose, and recover the money for the secured creditor. So that can in this case be ground upon which now in this case it can actually be appointed. Then check the security instrument provisions, like in this case the debentures or charge must expressly confer the right to appoint a receiver. This is what you're having to say. Under the agreement of lending of the money, that instrument upon which in this case they signed off to lend the money, the secured creditor had actually been given the leeway by the company to appoint what? A receiver. And therefore he is granted that right in this case to be able to appoint what? A receiver. Then issue a formal notice of default. So the secured creditor serves the company with a notice of what default under the security agreement. Then appoint a qualified what? A receiver. The creditor selects a licensed practitioner, insolvency practitioner, to act as a receiver. Then the deed or the agreement under the lending of the money will likely be executed. Then the company will likely be notified, and the relevant stakeholders will likely be notified. So the receiver appointment must be communicated to the directors, employees, and other relevant parties. Then lodge notice with what? The register of companies. So a statutory notice of appointment is filed as required under the Insolvency Act. Then the receiver basically will be able to take over the control of the assets under charge. The assets under charge. Then he'll be able to comply with what statutory. So the receiver must act in accordance with what the Insolvency Act and the terms of appointment. Then a report to the appointing creditor and the register of companies as to how far in this case he has been able to recover the assets for the specific creditor. So that's what in this case will likely happen regarding appointment of a receiver for a secured creditor of the company. For a secured creditor of the company. Yeah, so we can look at in this case August 2023 question number 6A. Highlight 6 offenses relating to liquidation of in this case what? Companies. Or what in this case they can be able to reframe this question by having to ask what are the offenses that can actually be committed by the liquidator when he's having to undertake what? Liquidation. So the offenses that can actually be committed by the liquidator when he's in this case having to undertake what? Liquidation. So if in this case the company property in this case is actually concealed, or in this case is actually hidden, so hiding, destroying, or removing assets to prevent them from being available to creditors. Or a falsification of in this case the company affairs, the company status. So the company status must in this case actually be ascertained by the liquidator to understand, like in this case, how much of assets are there, how much can actually in this case be realized or be gotten from the assets to settle the liabilities on liquidation, to settle creditors on in this case what? Liquidation. So if it happens, these records of account of the statement of affairs have actually been falsified, then that is part of in this case what? The offense that could end up having to be committed. Then you can have fraudulent trading, so carrying on business with intent to defraud creditors or for fraudulent purposes during liquidation. So if in this case it happens, maybe those who are involved in the liquidation process, they're in this case involved in fraudulent trading, for example, disposing of assets by having to make, for example, secret profits without having to reveal the profits, then that means that's what you're having to call what? Fraudulent trading during liquidation. So it will end up having to be an offense because the interest of the key parties, who are the creditors, who their dues are supposed to be settled on liquidation, is not having to be fulfilled. And therefore, if it happens, the parties who are involved in the liquidation process are involved in this kind of activities of fraudulent trading during liquidation process, then in this case, they can actually end up having to be liable. Failure to keep proper accounting records during the liquidation process. So at the end of each and every year, so the liquidator has to be able to give a statement of affairs with regard to as to how far he has undertaken the liquidation process. So failure to which in this case, he can actually be liable. So not maintaining required financial records prior to liquidation. Then undue preference to certain creditors. So like in this case, he's having to prefer, or in this case, not having to prioritize the creditors as per the requirements under the law. Like in this case, by having to pay, first of all, secured, unsecured, liquidation expenses, secured, unsecured, but maybe in this case, it could be unsecured creditor, but he has been given priority. So that's having in this case to do go against the requirements in terms of priority of payment during liquidation. So undue preference to certain creditors. So paying or securing one creditor in a preference to others shortly before liquidation. Non-disclosure of liabilities or assets. If it happens in this case, part of the liabilities or assets haven't been disclosed fully during the liquidation process, then that is part of, in this case, the offense that could end up having to be committed. So failing to fully and truthfully disclose any debts or liabilities or assets that are present during liquidation or are supposed to, in this case, be utilized for liquidation. Then we have, in this case, April 2023. So question number 3A and B. Highlight 4 grounds upon which the Commissioner of Insurance might petition for the winding up of a company. So this just almost, in this case, having to look at the reasons that we've been able to talk about. So highlight 6 powers that a liquidator can exercise without the sanction of the court. So these powers, you also in this case looked at them, the ones that he can be able to exercise without the sanction of the court. So you can start with the second part. What are the powers in this case is said the liquidator can be able to exercise without the sanction of the court? There are those powers he can be able to exercise by being sanctioned or being called upon by the court. There are those he can be able to exercise without having, in this case, the court sanctioned. The powers that the liquidator can be able to exercise without the sanction of the court. Appoint an advocate to represent him in a court, to represent the company in a court. Sell movable assets, to make a call on amount of unpaid shares. Employ agents to perform tasks or duties they cannot be able to perform. Raise money when required from having to do dispose the assets. Inspect the record and the returns of the company without, in this case, having to pay any fee at the registrar's office. To draw, accept, and endorse any negotiable instrument on behalf of the company, like a check, you can be able to draw it. So there are those ones. They're actually in your notes. So we had, in this case, looked at them. So we have those powers sanctioned by the court and those powers that he can be able to exercise without a court sanction. You have to take note of them. So they can easily test. They can easily now, in this case, test powers with a court sanction, that are sanctioned by the court. Powers that, in this case, are sanctioned by the court. They can now test what are the powers sanctioned by the court. So you need to check on that, check in your notes to be able to see them. So the grounds upon which, in this case, the Commissioner of Insurance might petition or call upon for an insurance company to be wound up It can be, for example, in this case, if the insurance company is insolvent, or in this case, it is unable to pay or settle its liabilities as they actually end up having to fall due. So failure to maintain statutory reserves, or in this case, capital. So for example, the company's financial position falls below the regulatory requirement. So this just like in this case, having to say the company is not having to perform, or the insurance company is not having to perform so well financially. Or contravention of the Insurance Act, so persistent breach of the insurance laws or regulations. So if in this case, it is in the public interest that in this case, the insurance company does be liquidated, or as a result of, in this case, what may be a breach of the interest of a policy holder. Interest of a policy holder. So those are part of the reasons. So that in this case can end up having to make the regulator of insurance companies to call upon for an insurance company to be liquidated. If it has been declared to be insolvent, that it is not able to pay back its premiums. So it is not paying back, or in this case, paying back the compensation to the parties who have actually been insured. For example, in this case, if your insurance policy has matured and maybe a number of them haven't actually been paid. So that means in this case, they are insolvent. They're not able to pay. When these claims come before them, they're not actually able to pay. So that means they are insolvent, and therefore in this case, it means there's no essence of them having to continue to operate. If in this case, they haven't met the statutory requirements, or they have actually in this case acted illegally, as per in this case of the Insurance Act requirements. So the Insurance Act basically gives guidance as to how insurance companies are supposed to operate. So they have to, in this case, conform to that particular law regarding as to how they're supposed to operate. Contrary to this, it means they would have actually been able to act illegally, and therefore in this case, it means they can actually be liquidated. So failure to maintain statutory reserves, or in this case, of capital. So they, like in this case, a minimum reserve of capital you're supposed to maintain as an insurance company. So the regulator basically has to check each and every time as to whether in this case you have this reserve, just as an indication you are financially stable as an insurance company to service your liability anytime they might actually fall due. You can be able to service because you have that adequate in this case reserves or capital that you have. So those are part of the reasons that in this case can end up having to cause an insurance company in this case to be liquidated. Then powers that the liquidator can exercise without the sanction of the court. So you've actually been able to mention them. So sell the company property, collect debts owed to the company, carry on the business of the company, raise money on security of assets, appoint agents to support him in his work, so execute documents, like in this case, negotiable instruments, like maybe a check, he can be able to sign it off on behalf of the company. So we've been able to say in this case, he can be able to appoint advocates to be able to, in this case, safeguard or protect the interest of the company, if in this case there's any matter before the court. So these kind of powers, you can be able to exercise them without having been sanctioned or approved by the court, without having been sanctioned or in this case approved by the court. So you have these ones. Summarize 5 circumstances under which the company might be liquidated under the just and equitable grounds. This one you've already looked at it. So I already in this case indicated it can be tested. So you can see it was tested there. So the just and equitable grounds upon which a company could end up having to be liquidated. So they are there. So if there's failure of substratum, where there's a complete deadlock in management, so the management cannot be able to see eye to eye. So those are part of the just and equitable grounds upon which the company can be compulsorily liquidated. So just and equitable grounds. So the complete deadlock, the company is continuously making losses and there's no chance it will make a profit, where the affairs of the company are being conducted in a manner which is unfair or prejudicial to the minority, where the conduct of a director or a shareholder is in such a manner that in this case there's like a breach of trust amongst the directors, or maybe in this case shareholders, if the company is involved in fraudulent or illegal business, if there's an exclusion in management, whereby part of the management has actually been excluded from having to take part and parcel in the management of the company. So this could be part of the reasons that can be petitioned before the High Court. And in this case, it can be able to give a liquidation order, a compulsory liquidation order. Then December 2021, On forming the view that a company is or will be unable to pay its debts, the liquidator shall, among other things, prepare a statement setting out the financial position of the company. Describe 5 categories of information that a company statement of financial position should contain. What do you think a statement of financial position should contain? What do you think a statement of financial? This one you can at least teach me. You can at least teach me some financial reporting. I can see you're saying assets. Assets, I can see you're saying current liabilities. I can see you're saying current assets. So they have asked 5. They have asked 5. So this one at least you can teach me from your financial reporting. You can teach me from your financial reporting. So you have in this case equity and capital. Equity and capital is correct. Is correct. Non-current liabilities is correct. So John, we'll share the document. So we'll share the document. You will share the document. So you don't have to worry. So you shouldn't start worrying now. If you start worrying now, things might, in this case, go marambas for you. You need, in this case, not to start worrying. You need not to start worrying. So I can see someone is asking, Sela Basilisha. It is not yet. It is not yet. Jaisha. Badi Jaisha. It is not yet. It is not yet. So we finished on Monday. Elizabeth, we finished on Monday. Then John, we are going to share the document after the class. So this document is yours. This document is yours. This document is yours. Yeah, so you can see you people are at least having to teach me some FR here. You are saying current liabilities. It is correct. So we can have current assets, non-current assets. We can have equity. We can have current liabilities. We can have non-current. There are 5 non-current liabilities. They were asking for 5 categories. 5 categories. This one was very easy. So I wish they bring a question like this one. So we can have non-current assets, current assets, and you're supposed to describe them. So for example, in this case, we talk about non-current assets. These are basically, in this case, assets that are long-term in nature. They'll be able to, in this case, exist for a period of more than a year. Is that correct? I'm not sure. Current assets, they are those simply assets that will end up having to exist for a period of, in this case, less than a year. Equity is basically, in this case, the capital of the company. The capital of the company that is there, in this case, to safeguard or protect the interest of what? The creditors, whenever the company is having to be liquidated. So non-current liabilities is what, in this case, the company is liable to settle in the long term. For example, it can be long-term loans or something like that. Then current liabilities are those amounts that, in this case, the company is liable to settle within a period of a year, not having to exceed the what? More than a year. So that's how you could have actually been able to answer that one. So that one was actually very simple. Was actually very simple. So when you talk about fixed assets, it's just the same as having to say non-current assets. It's just the same. When you talk about fixed assets, just the same by having to say non-current assets. We can go to the next one. So you can see enumerate. This one is September 2021. Enumerate 4 grounds for liquidation under just and equitable grounds. Then summarize 3 consequences of a winding up order. The grounds for just and equitable, this one you've already looked at it. So Blessy, we've already looked at this one. It's just a repetition. You can see some of these patients, they end up having to repeat. Like this one, just and equitable grounds. Then what are the consequences of a winding up order by the court? This one now you can be able to try. What are the consequences when the court gives out a winding up order or issues a winding up order to the company? What will be the repercussions? What will be the repercussion, the consequences when now the court declares the company is under compulsory liquidation? What will be the consequences? It discharges the duties of the employees and the staffs immediately. That's very correct. That's very correct. Wow. That's very correct. The employee cease duty immediately. Loss of employment. But now in this case, Flo, you can both be able to define and say discharges duties of employees and what? And staff. Unless in this case, maybe they are required there for the beneficial liquidation of the company. The powers of the board in this case are immediately terminated. The powers of the board of directors are immediately terminated. The powers of the board are immediately terminated. It in this case acts as it acts in the favor of, in this case, what creditors and what the contributors, because now in this case it means all the assets or resources of the company will be gathered together to settle creditors, and in case of any residues, they can in this case end up having to be shared amongst what? The shareholders. The duties of directors cease. No legal proceedings can commence against the company unless in this case the court has given what? Permission. Very correct from Francisca. Very correct from Francisca. The company ceases business, not really, Jen. So not always that in this case when the liquidation basically commences, the company will cease business. Sometimes it can continue for a while. Then in this case, it can end up having to cease after, in this case, maybe all the assets have actually done what been liquidated. So that's what you're having to say. Sometimes they can actually end up having to terminate the employees, or they can retain them for the beneficial liquidation of the company. If there are any inventories to be sold, they'll end up having to still trade and sell all those inventories as an asset. Then in this case, they can be able to say now they have ceased what? Business. It operates in favor of all what the creditors. So you've been able to give all the points. So they're still actually in your note. You take your note in this case to be able to see them. You can see most of you having to give them. They are there. They are there. They are there. So they are here. They are there also in your notes. You can be able to get them. This one is May 2021. So May 2021 is having to call upon us to indicate them. So outline 5 circumstances under which an unregistered company can be liquidated, can actually be liquidated. So unregistered company is a company that is having to operate like what? Illegally. In this case, it has not actually been what? Properly registered. Is having to operate what? Illegally, or in this case, it has not actually been what? Properly registered. It has not actually been properly registered. So if in this case, that is the case, then the reasons that you've just actually been able to look at, if the company is unable to pay its debts, if the company has ceased to be a going concern under just and equitable reasons, so those are part of the reasons you can be able to give. Once you've just already been able to look at, so they'll in this case be part of the reasons that could be able to lead to such kind of a company having to be liquidated or its life having to come to an end. Describe the powers and duties of the official receiver in his capacity as a corporation. So what in this case will be the duties of a receiver. So in this case, he can be able to secure all the assets of the company on behalf of the creditors, to take control and manage the affairs of the company for the benefit of a creditor, to pay up as much debt as possible that is outstanding in the company, to sell off the assets, to pay up as much debt as possible, to give any recommendations and report as to how far receivership has been carried out by himself as the receiver. Then you can look at this one as the last one. Highlight 7 ways through which the office of the deputy official receiver might become vacant. So they can be in this case an assistant to in this case a receiver. So he can voluntarily resign. He can resign if his license as an insolvency practitioner is revoked or cancelled, if a resolution has been passed appointing another person to his office, if he's removed from office, maybe by the appointing parties authorities, that's like in this case what maybe the creditors. If the receivership or insolvency is over or has come to an end, if there's an order from the court for the liquidation of the company to commence. So his duties basically automatically will likely be terminated. In case of death or insanity, if the insolvency process by the company is actually over or has actually come to an end. But this is just basically what a repetition. Even this is a repetition with this one. So maybe we can be able to remove this one. So it's just the same. We can be able to remove that one. Those are part of the reasons as to why in this case a deputy official receiver office can actually end up having to come to an end. So I think I'm going to end there for this one. I'm going to end there. So these other questions, when I'm going to share the document, you can go through them. But it simply means in this case, you have to revise just around those areas we've been able to talk about regarding administration, receivership, and liquidation of companies. So there are a number of questions here. Some of them are just repetitive. So as to what in this case, you've already been able to look at. So let me end there for now. For this topic. So we have to take a break. Let's take a break. Then when we come back, I want to look at questions from the topic of the last topic, which is actually in this case, foreign companies or companies incorporated outside Kenya. So that's what in this case I want as we look at. So a break of 5 minutes, then I think it will be okay. We can proceed, we can continue. So confirm there whether we can continue. Confirm there whether we can continue or we can go to sleep. Confirm there whether we can continue and go to sleep. We can go to sleep. Yeah, I can see everyone says yes, 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 we can. Yes, we can continue. Yes, we can continue. So we can, in this case, look at the very, very final topic, which is actually topic number 16. It is foreign companies. Sometimes we call it companies incorporated outside Kenya. So this is topic number 16. So it's the very final one we're going to look at for revision for today. So topic number 16. This one also we did it in our previous class. So it's the final topic we looked at. So under this topic, we looked at what is a foreign company, what are part of the requirements regarding registration of a foreign company. We looked at what are some of the breaches that a foreign company could actually end up having to find itself in. We looked at part of, in this case, the filings that the foreign company should be able to file with the register of companies and other requirements regarding, for example, the name of the company. So the first question here is from April 2025. April 2025, question number 7. It says, with the reference to the Companies Act, describe 5 circumstances in which the name of a registered foreign company can be struck off from the register of foreign companies. So under what circumstances can the register of companies deregister? This is what they're having to ask. Under what circumstances can the register of companies deregister a company in the register at the registrar's office? So this one we looked at it. So what are some of the reasons? If it is unable to pay its debts, if it is involved in fraud, the company is engaging in illegal activities, fraud, illegal, fraud, illegal. Everyone is having to say fraud, illegal, fraud, illegal. But what are the other reasons? If it has seized business, in Kenya, if it has seized business in Kenya, that is wonderful from wonderful. That is just wonderful from wonderful there. Then is having to say if the foreign company is under liquidation in the parent country or in the origin country, that is correct. If winding up has already commenced in the origin country, if in this case it has already been wound up abroad, because that's where it was initially registered. If it has failed to meet the 30% shareholder minimum requirement for local citizens, it has closed operations in the origin country. Those are the reasons. So they are here. They're also in your notes. You can be able to check your notes. You'll be able to see them there. Cessation of business in Kenya, failure to maintain a registered office or an agent. If it doesn't have, in this case, like a local representative. So this is the person we called what? A local representative. Local. But in this case, doesn't have a local representative. Winding up or dissolution in the home country has already commenced. Failure to file what statutory returns with the register of companies. If there's a request by the company, in this case, that it ends up having to do what to be deregistered from having to operate in Kenya. So those are part of the reasons that in this case will end up having to lead to a foreign company being removed from the register at the registrar's office. So you can go to December 2024. December 2024. Let's look at what happened in December 2024. It is provided by the law that companies incorporated outside Kenya should provide certain documents and information within 30 days of establishment of business. Explain 5 documents and relevant information required by the registrar of companies to register such companies. So what is the documentation required? What is the documentation required when you're having to register a foreign company? Documents required when you're registering a foreign company. Doris. What are the documents required when you're registering a foreign company? Certificates of registration from the foreign country or from the origin country. Certificate of incorporation from the origin country. Notice of address of the registered office in Kenya, that is correct. The copy of the memorandum and the articles of association. List of directors, details and particulars. Certificate of incorporation, list of directors and actually particulars. Address of the registered office. Address of the registered office. Address of the registered office in Kenya, and also in this case in the foreign country. A local representative. So they must in this case be able to appoint a local representative, or particulars pertaining to, in this case, the local representative, documents pertaining to particulars of the local representative. Details of charges, with any, if in this case the company happens to have actually charged any assets in Kenya as a country, they must be able to give particulars of those, in this case, charges. Those are part of the documents. So they're in this case also in your notes, you can be able to check. So certified copy of the charter or certificate of incorporation from the origin country, the list of directors and the company secretaries, a statement of subsidiaries of the holding company, address of the principal or registered office in Kenya and the country of origin, name and address of the local representative or authorized agent in Kenya. So those are part of the documents or particulars required when they're having to register a foreign company. When you're having to register a foreign company. So let's look at December 2023 question number 5C. Examine 3 legal consequences that may befall a foreign company operating in your country if it fails to comply with the legal requirements as provided for in the Companies Act. Examine 3 legal consequences that may befall a foreign company operating in your country if it fails to comply with the legal requirements provided for in the Companies Act. So what are in this case the consequences? For example, in this case, if a foreign company doesn't comply with the relevant laws, what can happen to it? What can happen to it if it doesn't comply? It can be deregistered, and that is automatic. It can be deregistered because it's not having to comply. So Martha, instead of having to say it can be closed down, you just say it can be deregistered by the registrar of companies, or certificate of incorporation can be revoked or cancelled out. It can be fined or it can be penalized. It can be fined or it can end up having to be penalized. There can be seizure of assets and the recovery of taxes. It can be fined or in this case end up having to do what to be penalized for breach of, in this case, relevant laws, upon which in this case it's supposed to be able to do to conform. So we can talk about in this case penalties and fines. The company may be liable to monetary penalties for non-compliance. This includes fines imposed on both the company and its officers for failing to file maybe required documents like annual returns, failing to appoint a local representative, so they can actually be fined, operating without registration. So then in this case, it can also be able to lack the inability to enforce legal rights because it won't actually be legally recognized. So it won't be able to, for example, go to a court and in this case action or sue another party or third party because in this case is not having to conform to the relevant laws. Is not having to conform to the relevant laws. So non-compliant foreign company may not be permitted to initiate legal proceedings in a Kenyan court because in this case is not having to do conform to the relevant laws. So it won't be able to enforce its legal rights before the court. Then it can be registered, as you've been able to mention, or they can strike off the name of this company from the register at the registrar's office. They can strike off the name of this company from the register at the registrar's office, So those are part of the consequences. Then state 4 particulars to be found in a certificate of registration of a foreign company. So in this case, once it is registered, you can see the name of the company on that certificate, a unique identifying number, the date when it was registered. Then the certificate will also be able to indicate, is it a limited company or unlimited? It will be able to indicate whether it is a private or it is a public company. It will basically bear the signature of the register of companies. Then also it will be able to have the common sale of the register of companies. So those are part of the particulars to be found in the certificate of registration of a foreign company, or certificate of registration of a company will bear those particulars. Then with the reference to registered foreign companies in your country, explain the obligations of a foreign company, describe the liability of a local representative, then identify 4 changes in information or documentation that a foreign company must notify the registrar within a period of 1 month, time of their occurrence. So like in this case, the first one here, what do you think will be the obligation of a foreign company once it has been registered? They'll be under what mandate once they have already been registered? Like what will be their obligation to be able to fulfill under the law, or maybe in this case, under the Companies Act? What do you think can actually in this case be their obligation once they have been registered? Registration of charges, they'll likely be in this case be under mandate to register charges. They'll in this case be under obligation to make annual returns to the Register of Companies or file relevant returns. They'll have to in this case be under obligation to ensure what compliance with the relevant laws, like in this case the Companies Act. They can of course open a bank account. They can open a bank account. They'll in this case be under obligation to appoint what a local representative. So that office should be able to be having someone having to represent their interests in the country. So those are part of, in this case, what the obligations, the ones you've mentioned there. They'll be required to register charges. So in this case, they have charged any of their assets, they'll be called upon to register these charges with the Register of Companies. So within a period of, in this case, what maybe 14 days, or maybe it's supposed to be 30 days, not 14, but 30 days. Then they'll have to maintain what accounts, proper accounts. So a registered foreign company shall at least once every calendar or at interval of not more than 15 months lodge a copy of its financial statements with the Registrar of Companies. So then in this case, they'll have to make annual returns or certain returns, in this case, to the Register of Companies. So part of the returns they are supposed to make is a return on any alteration of what? The memorandum. For example, if they have altered the memorandum, they have to, in this case, inform the Register of Companies. They have been able to do what? Alter their memorandum, or in this case, what? Their articles. So a return regarding changes in directors, maybe they have changed directors. A return regarding changes in particulars of directors. So names and address of persons authorized to accept service of notice on behalf of the company. So those are the local representatives. So if they have changed them, they'll have in this case also be able to, they'll be under obligation to file that notification or return to the Register of Companies. So a return regarding maybe change in the address of the registered office. Maybe they have shifted their registered office. So they'll have to, like in this case, make a return indicating what is in this case their new location or new registered office. New registered office. Then part 2 or Roman 2, describe the liability of a local representative. So we say this local representative is basically the person now within the country having to represent the interest of, in this case, what this foreign company. And therefore, he'll be under obligation, he'll likely in this case be under obligation to ensure the company in this case is having to conform to all the relevant laws, having to in this case guide as to how foreign companies are supposed to operate. So failure to which he likely end up having to do what? To be liable. So he's in this case under liability, for example, if the foreign company breaches the relevant regulations or statutory requirements under the Companies Act regarding as to how foreign companies are supposed to operate. If the company breaches that, then the person will end up having to be responsible. It will be the local representative. So they are responsible for ensuring compliance by the company of what? The Companies Act, and may be personally liable for any penalty imposed on the company for contravention or non-compliance of what? Of the Act. So then in this case, a foreign company shouldn't actually end up having to operate without what? A local representative. So for a period of more than 21 days. Otherwise, the foreign company can be penalized or be fined. Then what are some of the changes in information or documentation that a foreign company must notify the registrar within a period of, in this case, 1 month. So these ones are just basically what we've been able to list here, the returns. The returns that are supposed to be met. So if all these has happened, like for example, they have changed the memorandum, they have to, in this case, file this documentation of the change with the register of companies. Then a return regarding any changes if they have changed directors. So that's part of the information. They have to ensure that in this case they have notified the registrar within a month. So changes in the particulars of directors, changes in directors of the company. If in this case there's a change in the name and the address of, in this case, the local representative, they have to notify the register of companies. If they have changes, in this case, their registered office, their principal office for business operations, they have also, in this case, to do what? Inform the registrar of companies. Then we have this one here, September 2021. So with regard to foreign companies incorporated outside Kenya, outline 3 offenses which might be committed by a foreign company. So this one we've already looked at it. It's just a repetition. Like in this case, what are the liabilities upon which in this case the foreign company can end up having to be liable? Then state 3 provisions that might be contained in a foreign company's regulations governing the registration of a specified charge of a property in your country, which belongs to a foreign registered company. So the provisions that might be contained in a foreign company's regulations governing registration of specified what charges? Registration of specified charges. So, so foreign companies are to register charges on a specified property that are in Kenya. So if in this case it happens that property is actually situated in Kenya, then part of what in this case will likely be in these documents pertaining to registration of the charges, it should be able to indicate that this particular property is actually situated or maybe located in Kenya. Then records in regards to the specified charges. So in this case, if it happens, there are, for example, those beneficiaries, the data upon which in this case the charge was actually created, all these particulars have to be captured in that document calling upon for, in this case, what registration of the charges. Then if there are any consequences that can end up having to befall the company, if in this case there's actually any contravention to uphold the charges, then in this case, they should be able to indicate under what the document. Then the circumstances under which the property can be regarded as having to be in Kenya has to be explained. So what is having to indicate that this particular property in this case is situated in Kenya, and therefore, if it is under charge by a foreign company, it is supposed to be registered with the registrar of companies. Then the last one that you can be able to look at, it is this one, May 2021. So with respect to companies incorporated outside Kenya or your country, explain 5 documents which are necessary to accompany the application. This one, we've already looked at it. So certificate of incorporation is a repetition of that other question we've looked at. So we've looked at, so we can have this one. So maybe it could be the last one. XYM Limited is a company registered in South Africa. The company intends to register a branch in your country as a foreign company. With the reference to the above statement, summarize the procedure for registration of a foreign company in your country. Explain the manner in which the foreign company might own land in your country. So the way in this case, a foreign company can be able to own land in your country. So for in this case, issues pertaining to land, we said that for Kenya, if in this case you are a foreigner, and in this case, the same case, if it's a foreign company, number one, it is in this case only entitled to own what we call a leasehold, not a freehold. So for a foreign company, in this case, number one, you're having to say number one, a foreign company in this case is entitled to own a leasehold under the Kenyan Constitution, but not a freehold. So a leasehold in this case is a right over land that has a definite or defined period of time upon which you can be able to enjoy right over that land. It normally in this case goes up to an extent of 99 years. So they can't in this case own a freehold, which in this case the rights of ownership or the rights over the land are normally indefinite. There's no defined period. So you pass on to your next generations. So that's in this case a freehold. But in this case, for foreigners or foreign companies, they're entitled to in this case only be able to own in this case what we call a leasehold. Then number two, if it happens in this case, a foreign company is interested to have a right over a freeholder, then in this case, maybe they can actually end up having to charge a freehold land in another company. For example, in this case, if it happens, this company is a debenture holder in another company. So the asset under charge under that debenture can be a freehold, and therefore indirectly they would have actually been able to acquire rights over a freehold. So that's another way in this case as to how they can obtain rights over land as a freehold, whereby in this case they actually charge a freehold land as a security whenever in this case they have acquired what may be debentures in a company. Number three, they can actually end up having to serve as a director in this case what? A company that is having to own freehold land. And as a result, because in this case they're having to serve as a director, or they have seconded someone to serve as a director on their behalf as a company, then they have control over that, in this case what? Freehold land, which is part of the property in this case owned in a company, which in this case they're actually what? Directors. So those are the ways as to why in this case a foreign company or foreigners could end up having to enjoy rights over land in Kenya. Then the procedure, so if in this case you want to be registered, you have to bring all the documents we've talked about. Then you have to, in this case, fill out relevant documentation or maybe forms with regard to having to seek to register as a foreign company. So you have to, in this case, do what? Ensure you have actually been able to file your application in a prescribed format, or give the prescribed information in a prescribed format. The number two, ensure that in this case, the foreign company has been able to meet the 30% rule, which in this case, it means the ownership or the shareholding of the company should actually be at least by 30% Kenyan citizens. 30% Kenyan citizens. Then you have to pay a prescribed fee. Then you submit all the documentations you've been able to talk about, those certificates of incorporation from the origin country, list of directors. So everything, all that has to, in this case, be filed with the register of companies. Then in this case, eventually, he'll be able to assess. If in this case it happens, you meet all the threshold or the requirements, and you've submitted all the documentations required, then the register of companies can now be able to issue a certificate of incorporation for the foreign company. So I think we can end there. So let me end there for now. So we in this case looked at topic number 15 and 16. So next time we'll be able to look at, in this case, topic 12, 13, and 14. So we look at 12, 13, and 14 in our next class. That is actually in this case on Monday. So on Monday we look at 12, 13, and 14. 12, 13, and 14. 12, 13, and 14. But this Friday, so during our lunch, our super revision class, we'll be able to look at topic 11. So we look at topic 11 in our Monday revision. So it means by Monday, we would have already been able to cover around 6 topics for revision purposes. So I'm going to share this document. In this case, use it for your revision as you prepare for the exam. Take note, the exam is almost. So you need, in this case, to try and actually burn the midnight oil. Try your level best, not to sleep a lot. But in this case, at least be able to adjust your mode of studying. So you can actually at least try to be aggressive, more aggressive towards these last minutes. Try to be a bit more aggressive in terms of your revision. Try to be a bit also very strategic in your revision. Like in this case, you need to, like in this case, understand which are, like in this case, the most areas that I need to be able to, like in this case, focus on in terms of revision. So that's what in this case is actually very important to be able to pass this exam. So that's it. So let's in this case meet on Friday. So and see how far we can be able to go with the revision. Otherwise, thank you so much and have a good night. So let's catch up on Friday.